This presentation is focused on a crucial element of contractual formation, the concept of consideration. This concept of consideration is the principal way in which English courts decide whether an agreement that has resulted from the exchange of offer and acceptance should be legally enforceable. It is possible to see consideration as an important indication that the parties intended their agreement to be legally binding as a contract. In exchanges where there is an immediate, simultaneous transfer, for example, a transfer of goods for money, as in most everyday shop transactions, the doctrine of consideration applies in theory but rarely causes any practical problems. However, it is where somebody says, for example, I will deliver these goods to you next Thursday, or I will pay you £1,000 on the 1st of January, that it becomes important to decide whether that promise is supported by consideration. This means that something has been given or promised in exchange. A quick way to remember what consideration is about is to think whether in any given transaction there's been a promise to exchange something valuable to the other party. In the case of Carey versus Misa in 1875, it was stated that a valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss of responsibility given, suffered, or undertaken by the other. English law treats the making of a promise as distinct from its performance, as capable of being consideration. Thus, in a wholly executory contract, the making of the promise by each side is consideration for the promise made by the other side, rendering both promises enforceable. Consideration must move from the promisee, but not necessarily to the promissor. One could promise to pay a sum to a third party, for instance. Also, consideration must be sufficient, but need not be adequate. The requirement that consideration must be sufficient means that what is being put forward must be something which the courts will recognize as legally capable of constituting consideration. The fact that it not be adequate indicates that the courts are not generally interested in whether there is a match in value between what is being offered by each party. It was established in the case of Chappell versus Nestle from 1960 that a contractual party can stipulate for what consideration he chooses. The courts will not interfere just because it appears that the person has made a bad bargain. An area of particular difficulty relates to promises to perform existing obligations. There are three aspects to this topic, dealing with three different types of existing obligation which may be argued to constitute consideration. The first has to do with obligations which arise under the law independently of any contract. An example would be where a public official agrees to carry out one or more of their duties in return for a promise of payment from a member of the public. In that situation, the promise of payment will not generally be enforceable. This is either because there is no consideration for the promise, the public official, for instance, is only carrying out an existing duty, or more probably because public policy generally suggests that the law should not encourage the opportunities for extortion that enforcing such a promise would create. Where, however, the official does more than what is required by the existing obligation, then the promise of payment will be enforceable, as is shown in the case of Glassbrook Bros versus Glamorgan County Council from 1925. The second situation relates to obligations which are owed under a contract with a third party. For those obligations which are owed under a contract with a third party, the position is much more straightforward. The courts have consistently taken the view that this can provide good consideration for a fresh promise. The Privy Council confirmed in the case of Pao On versus Lau Yu Long from 1980 that the promise to perform an existing obligation owed to a third party can constitute good consideration. The third situation relates to obligations which exist under a contract with a person who has made a new promise for which the existing obligation is alleged to provide good consideration. There are two particular cases on this area which you should study carefully, Stilk versus Myrick from 1809 and Williams versus Raffy Brothers and Nichols from 1991. Stilk and Myrick was long accepted as establishing the principle that the performance of an existing contractual obligation could never be good consideration for a fresh promise from the person to whom the obligation was owed. The Court of Appeal's decision in Williams and Raffy raised the question of whether Stilk and Myrick could still be said to be good law. Lord Justice Glidewell pointed to the practical benefits that would be likely to accrue to the defendants from their promise of the additional money. You should note that the judge summarizes the circumstances where, in his view, the practical benefit approach will apply in 6 points, which relate very closely to the factual situation before the court and emphasize the need for the absence of economic duress or fraud. There is no reason, however, why later courts should be restricted by these criteria in applying the Williams and Roffey approach. Williams and Roffey has not, however, affected the related rule that part payment of debt can never discharge the debtor from the obligation to pay the balance. This rule, in fact, does not derive from Stilk and Myrick, but from the House of Lords decision in Foulkes v. Beer in 1884. The Court of Appeal in Re Select Move in 1995 confined the ambit of the decision in Williams and Roffey as regards debts. Further, in South Caribbean Trading v. Trafigura in 2004, Judge Coleman doubted the correctness of the decision in Williams and Roffey. A further rule about the sufficiency of consideration states that generally consideration must be provided after the promise for which it is given to make it enforceable. A promise which is given only when the alleged consideration has been completed is unenforceable. This is called past consideration. As with many rules relating to consideration, there is an exception to this rule about past consideration. The circumstances in which a promise after the acts constituting the consideration will be enforceable were thoroughly considered in the case of Pao On versus Lau Yiu Long in 1979. Lord Scarman laid down 3 conditions which must be satisfied if this exception is to operate. Firstly, the act constituting the consideration must have been done at the promissor's request. Secondly, the parties must have understood that the work was to be paid in some way, either by money or by some other benefit. Thirdly, the promise would be legally enforceable had it been made prior to the acts constituting the consideration. The doctrine of promissory estoppel is concerned with the modification of existing contracts. The position under the classical common law of contract was that such modification would only be binding if consideration was supplied and a new contract formed. The equitable doctrine of promissory estoppel has developed to supplement the common law rules. This allows, in certain circumstances, promises to accept a modified performance of a contract to be binding, even in the absence of consideration. The origin of the modern doctrine of promissory estoppel is to be found in the judgment of Judge Denning, as he was then, in the case of Central London Property Trust versus High Trees House from 1947. Estoppel arguably derives from the concept of waiver, which was recognized both by the common law and equity as a means by which certain rights could be suspended but then revived by appropriate notice. See, for example, the case of Hughes versus Metropolitan Railway from 1877. It was this case upon which Denning placed considerable reliance in his decision in High Trees. The concept of waiver, however, has not applied to situations of part payment of debts. The doctrine of estoppel has been considered in a number of reported cases since 1947 and now has fairly clearly defined limits. There are a series of key points which must be considered. For a promissory estoppel to operate, the following conditions need to be met. The first condition is that there needs to have been an existing legal relationship. The second is that the promise needs to have been relied on. It has sometimes been suggested that this reliance needs to be detrimental, but Denning consistently rejected this view, and it now seems to be accepted that reliance itself is sufficient. The third condition is that the estoppel can be used as a shield and not as a sword. This is related to the first point concerning the need for an existing legal relationship. Courts have held that promissory estoppel could not be used as the basis of a cause of action. Its principal use was to provide protection for the promisee. As Lord Denning put it, consideration remains a cardinal necessity for the formation of a contract, though not for its modification or discharge. English courts have resisted attempts to find an action on promissory estoppel. Note, however, the different approach taken by the High Court of Australia in Walton Stores versus Maher in 1988. The fourth requirement is that it must be inequitable for the promisor to go back on the promise. But what does inequitable mean? It will cover situations where the promisee has extracted the promise by taking advantage of the promisor. You also need to note that the doctrine is generally suspensory. Whereas contractual modification which is supported by consideration will generally be of permanent effect, lasting for the duration of the contract, the same is not true of promissory estoppel. While it is in operation, however, a promissory estoppel may extinguish rights rather than delay their enforcement. It is accepted that reduced payments made while the estoppel is in operation stand, and the promisor cannot recover the balance that would have been due under the terms of the original contract. Further, where the promise is prohibited by legislation, an estoppel does not arise. See Evans v. Amicus Healthcare from 2003 for a discussion as to the current state of promissory estoppel and its possible future development. Finally, estoppel rests on the existence of a clear and unambiguous statement. Where the words used to make the statement claimed as the basis for a promissory estoppel were ambiguous and capable of being interpreted in several ways, then the words could not be said to found an estoppel unless the representee sought and obtained clarification of the statement.